Alright, let's talk about defenses now. Infancy refers to any person who has not yet reached the age of majority. Obviously, do you really think that we could punish a 2-year-old for beating somebody up? No. I mean, my 1-year-old, slaps me all the time. I mean, come on. Is that a crime? No, because they can't form the requisite mental intent. Intoxication. This is a fun one. I'm sure we've all been there. You have 2 types, involuntary and voluntary. Involuntary intoxication occurs when a person either is physically forced to ingest an intoxicating substance or is unaware that such a substance contains drugs or alcohol. Spiking the punch at the prom. Okay? That's involuntary intoxication. Now, voluntary intoxication is rarely a defense, but it might be a defense when the person is extremely intoxicated, but it's going to be very limited. Insanity, again, going crazy. It can be a defense to a criminal charge because, again, it gets rid of the mental side, the mens rea. It's not there. Georgia follows the McNaughton rule, and another rule you may see is the irresistible impulse. What about mistake of law? Ignorance of the law is no excuse, but obviously there's an exception to everything. But mistake of fact, that's interesting. Defense if the mistake negates the mental state necessary to commit a crime. Alright? So I pick up this toy. I think it's my toy. Okay? Whoops. It's actually Bob's toy. That's a mistake of fact. Now, consent. That's another interesting one. Not a defense to most crimes because, the law forbids murder, prostitution, and everything else you can think of. But consent is an interesting thing. Obviously, we have 2 people playing football. They hit each other. That's battery. But they consented to that battery. But did they consent to a cheap shot after the whistle was called? No. Okay, you see how that works? Duress. Rob that bank or I'll kill you. That's duress. Exists when the wrongful threat of one person induces another person to perform an act that he or she would not otherwise have performed. Alright, so if someone were to put a gun to my head, and say, go rob that bank or I'll kill you, what do you think I'm going to do? I'm probably going to go rob the bank. Now, would I normally rob a bank? No. Because I know that if I were to rob a bank, I'd get busted. Okay? Justifiable use of force. Self-defense. Alright? In a nutshell, this is how it works. If someone comes at you with their fists, you can use your fist back. If someone comes at you with a knife, you can use a knife. If someone comes at you with a bazooka, use a bazooka. That's light force. Alright? But look at deadly force and non-deadly force. Non-deadly force is probably, fighting. Deadly force is pulling out the gun. Okay? Necessity. Justifiable if the harm or evil sought to be avoided by such conduct is greater than that sought to be prevented by the law defining the offense charged. So it was necessary to do what I was doing. Entrapment. This is an interesting one as well. Defense designed to prevent police officers or other government agents from enticing a person to commit crimes in order to later prosecute them for criminal acts. One thing they left out with this definition is you are enticing someone who would not normally do that. Okay? And this is the police doing it. Statute of limitations. Certainly there are time limits that you need to bring a lawsuit or it expires. Immunity. You can make a deal with the prosecution, saying that if I agree to testify, you won't prosecute. That gives you immunity. What else do we have? Criminal procedures. Alright? The exclusionary rule. All evidence obtained in violation of the Constitution, spelled out in the 4th, 5th, and 6th Amendments, and incorporated into the states by the 14th Amendment, generally is not admissible at trial. Actually, the 5th and 6th are kind of funny. But the purpose of the exclusionary rule is to deter police from conducting warrantless searches and from engaging in other misconduct. Exceptions. Isn't it great? We have a rule and then 5,000 exceptions. inevitable discovery. Had the police, given their current position, found the item regardless, the exclusionary rule wouldn't happen. Good faith, police officer relying in good faith on a warrant, the warrant will be good.